Hello and welcome again, Employment Law Show. Good to have you along for the next 30 minutes. Please stick around, guaranteed to learn lots, some things you probably don't know. Share the wealth and share the knowledge as well when we're all done at the end of the day. If not, reach out to Lior anytime. Lior Samfiru, co-founding partner, Samfiru Tumarkin, the most positively reviewed employment law firm from coast to coast to coast. So feel free to reach out and talk to them. You will be in fine company for sure. 1-855-821-5900, the phone number, help@employmentlawyer.ca. We'll get to that email address. And another way to reach out, terminationquestions.com. What is that? It's a place you go. It's free and anonymous, and you can ask questions about your termination for a friend or a family member. Maybe it hasn't happened yet, but either way, it's a resource for you to use anytime, absolutely free. And Lior's team will be all over it. Today on the show, pal, we're going to get to 5 common questions about probation periods in Canada. That is on the way in just a bit. Some phone calls from our radio show across the country. But first, the week that was, what is cooking?
John, always great to be here and to talk about employment law. And I know that by the time this 30-minute show is done, you'll learn a lot about your rights. You'll learn a lot about things that are wrong, things that are right, what to do if you're facing certain situations. That is the point of this show. So maybe before we even get started, call some of your friends, say, hey, there's something interesting on TV right now, because I assure you, the issues that you may be facing with your job are shared by others. Okay, they're not necessarily unique, so other people may have the same questions. So let's spread the word that the law is here to protect you. The law is here to ensure that you have rights, that you have things to do if you're facing a workplace problem. Maybe it's a harassment situation. The law deals with that. Maybe you lost your job. The law certainly can deal with that and make sure that you're properly compensated. Put on a temporary layoff, forced to get a vaccine, whatever that issue is, there is a legal solution, there's a legal avenue that's available, and that's what we try to do on this show, to open up those avenues so that you know what to do in a workplace difficulty, in a workplace situation. But of course, despite what I said, I may not be able to cover your specific situation. Therefore, there's the second option, very easy. We'll give you my contact information throughout the show today so that you can reach out to me, we can have a private discussion, and I can help solve your problem. No issue, easy, we could do that anytime. But to get started, John, let me start with a situation that came across my desk over the past week. So I spoke with a gentleman who was hired as a production supervisor at a plant. He was hired during COVID. Unfortunately, things did not go well in the plant. Business was not as good as the company had expected, and they decided to let him go. They decided to let him go after 6 months. They had 2 production supervisors. They didn't need him, so they decided to let him go. No hard feelings. And when they let him go, the company said, we're going to give you 2 weeks' pay. You've been there for 6 months. Here's 2 weeks' pay. He called me, and he wanted to know what he's owed. So I told him, you're probably owed 4 to 5 months' pay. Now, this guy was a production supervisor. He's worked there for 6 months. He's 47 years old. That company could not wrap its head around the fact that he's worked there for 6 months and he's owed 4+ months' pay. They could not wrap their head around it. And, you know, I'm not going to badmouth anyone, but their lawyer was not particularly helpful, put it that way. So, unfortunately, this was a case where, because the company was not willing to improve its offer by more than a week or 2, we did actually have to take it to court. And guess what the result was? He got 4 months' pay, what he should have been paid to begin with. But I'm mentioning this to you here to remind you, employees and employers, that short service does not mean no severance or little severance. This guy worked for 6 months. He was owed 4 months' pay. The law actually treats short service employees disproportionately better than longer service employees. So you may have only worked for a few months. You could easily be owed a few months' severance. Okay, in most cases, unlike this situation that I just told you about, we can resolve it in a couple of weeks very quickly. But it is still the law. It's not going to change. That even if you work for a short period of time, a few months, a year, 2 years, you could be owed severance that's calculated in months. Sometimes, John, the severance can exceed the length of employment. Okay, so it's so important to get advice. You can go to pocketemploymentlawyer.ca and use our severance calculator tool there to find out exactly what you're owed.
You know, it's funny, though, because it'll sound bizarre to some of our viewers. They'll think, well, wait a minute. Yeah, I've heard you on the show before and on your radio show. You've got a person who's worked somewhere for 35 years and they get 24 months severance. This guy's done 6 months and he gets 4 months severance? How's that possibly fair? Why does that metric work?
Well, one of the reasons the severance exists, one of the ideas behind severance is to help you to find another job, is to give you a period of time to carry you until you find another job. Well, what flows from that is just because you work for a company for a few months doesn't mean you're going to find a job instantaneously. Just because you work for 6 months doesn't mean you're going to find a job in a week or two. In fact, it may be harder to find a job because you're going to have to explain to the new employer why is it that you only lasted 6 months in the previous job. So it's because of that that short service employees are given this long runway. They're given this time to find another job by getting paid more severance.
Again, you want to figure out any time what your severance could and should be. Lior's mentioned it, pocketemploymentlawyer.ca. That's the overall website. Within that, you'll find the severance pay calculator. It used to be a standalone website. Now it's rolled into pocketemploymentlawyer.ca. It's easy to use, takes about 30 seconds. It's absolutely free, and this is not hyperbole. Hundreds of thousands of people have used this thing and had their eyes open for sure. But you want to go to employmentlawyer.ca, that website where you want to flip over to the media tab, find our radio shows, find a station either online or broadcast where you can listen to those shows every week. They're an hour long, take a ton of phone calls. People have tons of questions about this topic, and we like to play them back here, don't we? So we'll get to our first phone call from the radio show, Lior, right now.
If I am considered I am incorporated, working for the same company, and they've had me on a schedule for 16 years and told me when I could take vacation, told me to adhere to a schedule. Am I an employee?
Do you work for anybody else or no?
Nobody.
How many hours are you working a week?
At least 40.
Do they provide any of the equipment or tools you use?
It's my own laptop. The only thing they provide is their work phone. I have their work phone.
This is such a common scenario. She works for a company for 16 years. They schedule her. They give her the equipment she needs to do the job. But no, you're not an employee. You're an independent contractor. John, you tell me, how could she be more of an employee than she is, right? It would be impossible. So bottom line is this. If you have a regular job that you've been doing for a while and the company decides where you do your job, how you do your job, you are an employee of that company, full stop. It doesn't matter if you've incorporated. It doesn't matter what you've signed, what you call yourself, how you pay your taxes. None of that ultimately changes the legal definition of what you are. That's why we have this Pocket Employment Lawyer tool that I mentioned. One of the things that pocketemploymentlawyer.ca does, it allows you to get an assessment, again, free and anonymous, of whether you are an employee or an independent contractor. Now, it's important to get that right for a number of reasons. Number one, if you're an employee, you're owed vacation pay, you're owed overtime pay, you're owed holiday pay, etc., minimum wage. But also, if you are an employee, really, but you've been misclassified, if you lose that job, you're owed severance, right? Because you're an employee. You know how many times, John, I've spoken with people that were quote-unquote independent contractors. They lost their job, and the company says, we're not paying you anything because you're an independent contractor. No. The law still considers them to be an employee, meaning they could get severance as much as 24 months' pay. So get that right and check out pocketemploymentlawyer.ca.
Because if it were that easy, I mean, for you, you've got a staff working for you. Don't hire anybody. You're all contractors. Have a nice day. It doesn't work that way.
Wouldn't that be a great solution, I guess, for many employers? I know how to not worry about these pesky employment laws. Let's just hire everyone as independent contractors. It doesn't matter if you work in a plant on the assembly line, if you're a kid working in a fast food restaurant, if you're an administrative assistant, it doesn't matter. You can all be independent contractors. And, hey, I don't have to worry about paying you vacation pay and all that. Doesn't work that way, okay? You've been misclassified, you're owed severance, you're owed all these rights. That's why it's important to get it right.
Not to mention the trouble you could get in with the old tax man if, it comes down the pike, right?
They don't have much of a sense of humor over at CRA, so they don't like individuals that have been misclassified. So if the company misclassifies someone, they could be subject to fines and penalties. Just not a good thing to do.
We've mentioned the website a couple times already, the show, terminationquestions.com. You can reach out to Lior, ask questions. One of his team will answer it, get back to you. First one for today, Lior, comes from Ryland. He says, I was laid off from my job as a software development manager after 14 years. They offered me 14 weeks of severance pay plus another 2 weeks pay as a bonus if I accepted the offer on the spot during the meeting. I declined so I could double check their offer. Did I make a mistake?
Well, I think that Ryland needs to be very grateful that Ryland did not accept this offer. So Ryland worked there for 14 years, was offered a total of 16 weeks pay.
Yep.
Well, here's the thing. That's not even close. And the problem is, if Ryland had accepted this, if Ryland signed on this dotted line and then realized, okay, I'm not so sure I should have done that, it's too late. Once you accept that severance offer and send it over to the company, you can't change your mind. And if you realize the next day that you're owed an extra year's pay, that's something you're going to have to live with and accept, because there's no going back. That's why there's no exceptions always. If you lose your job, you're staring at that severance letter. Maybe it's 1 page long, maybe it's 10 pages long. It does not matter. Whatever you think of that offer, you may think it's a good offer. Doesn't matter either way. You have to get some advice. You have to make sure that it's appropriate. Now, for Ryland, let's go back to Ryland. Again, 16 weeks pay after 14 years of service. Let's take Ryland's information and input it into pocketemploymentlawyer.ca, into our severance calculator tool, and let's see what Ryland is actually owed. So Ryland, 14 years, offered 16 weeks pay. You see the analysis there on your screen, and you see that Ryland is owed as much as 20 months pay. Not weeks, months pay. So the gap here is the difference between 16 weeks and 20 months pay. Now, I'm a lawyer, not a mathematician, so I'm not going to do the math as to how much that is. It's a lot. That's all I know. But that's why this example, I think, tells you more clearly than I ever could hope to tell you why it's so important not to accept and to go to pocketemploymentlawyer.ca.
It was almost I mean, they weren't forcing him, but it was, on the spot. If now, it's almost a pressure tactic saying, here, we'll bonus you 2 weeks. A little extra. I have a Casio. Here's 2 extra weeks of severance if you sign now. That's a pressure tactic. Now, you're not supposed to accept that. And what happens if there's a deadline? Maybe not on the spot, but it says this Friday we need that sucker back by 4 p.m.
It's not even what happens if there's a deadline. There is going to be a deadline. Every severance offer has a deadline. Friday at 5, Tuesday, whatever that deadline is. And you're going to feel compelled, I think. A lot of people, well, this expires. Oh my gosh, I'm stressed out about it. Don't worry about it. Your legal rights don't expire on that deadline. They don't expire Friday. You have 2 years to pursue your rights. What you're looking at is an offer that's a lot less than what it should be, so that deadline is meaningless. The only time a deadline would be relevant is if the company has happened to offer you a lot more than what you should be getting, in which case you want to accept before they change their mind. Listen, I've been doing this for 20 years. I'm still waiting for that to happen, for a company to offer even more than what they're obligated to pay. So don't worry about that deadline. Take whatever time you need to get the advice that you need so that you don't make a mistake.
All right, a lot to think about there. We'll give you a bit of a breather, get into a break, and when we come back, 5 common questions about probation periods in Canada. You need to know this, so stick around for it. In the meantime, phone number to reach out, 1-855-821-5900 and help@employmentlawyer.ca. We'll continue Employment Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru. If you didn't know, co-founding partners Samfiru, Tumarkin LLP, the most positively reviewed employment law firm in the country. You want to reach out, get the compensation you deserve, ask your questions. It could be a temporary layoff, maybe a severance question. Reach out, 1-855-821-5900 anytime. But an arena that a lot of people don't know anything about when it comes to their employment, and they should. And this is it, 5 common questions about probation periods in Canada. Because everyone is not necessarily on one. We'll start right there, right?
That's it. And the thing I want you to remember is that probation is not automatic.
Right.
You may have started a new job. You're there for the first time, first day. you're not on probation automatically. The only time you're on probation is if you signed an employment agreement that stipulates that you're on probation, that sets that term for you. If your employment agreement does not say that, or if you never have an employment agreement, by the way, that's better. You started a job on a handshake. Again, that's a good thing, not a bad thing. But if you didn't sign something that says you're on probation, you are not on probation. The law does not impose any particular rights or particular entitlements that your employer has in that situation. You're treated just like any other employee. So you're not on probation unless you sign something. You may want to go grab your employment agreement if you just started a job to take a look at that, send that over to me. I can tell you if you are, but it's not automatic, John.
Yeah, that kind of basically answers the first question. Neither the employee or the employer can assume automatically that, hey, you're on probation, I just hired you. Careful for the next 3 months.
Yes, absolutely. And the reason why that's important is that if you are, in fact, on probation, there's a lower threshold for letting you go, okay? And if you're not on probation, that lower threshold doesn't apply. So if you didn't sign something that says you're on probation, you are not, you're a regular employee. I know a lot of employers assume, oh, the first X number of months you're on probation. No, you're not, unless you sign something.
That leads us to our second question. How long can that be? 3 months, 6 months, 9 months?
So if, in fact, you did sign something that puts you on probation, you signed an employment agreement or job offer letter that puts you on probation, in most cases, that probation can only last 3 months. And the reason for that is that after 3 months, if you're let go, the company has to pay you severance. It's only in the first 3 months that the company can let you go without severance, and that only happens if you signed an agreement saying you are on probation. Now, by the way, John, I want to make it clear, if you did not sign something that you're on probation and you are let go in the first 3 months, you are going to be owed severance. You're not going to get severance in the first 3 months if you sign something, which is why the probation can really only last 3 months. If the company says your probation is 6 months, that's nothing. That's meaningless. They're going to have to pay you severance if they let you go after 3 months and a day.
Is there a situation where the employer can extend it, and if so, how much?
Not really. Okay, I know a lot of employers try to do that. Well, we're not so sure about you, so we're extending your probation. That's meaningless, because if it's already been 3 months and a day, and the company wants to let you go, they have to pay you severance, your full termination entitlements. They can't avoid that because they extended their probation. Okay, it doesn't work that way. So because of that, I don't see a value in extending it for employers. A lot of employers try to do that, not understanding that they're not really doing much. For the most part, probation can only be 3 months.
Is there a mechanism for an employer that if they let someone go, they have to pay severance pay within that probation period?
So generally speaking, if you sign an employment agreement that says, number one, you're on probation,
yep,
and number two, if we let you go during the probation, we don't have to pay you severance, then the employer is allowed to let you go in that first 3 months pretty much for any reason, and they don't have to pay you anything. But it has to do both of those things. You're on probation, and we're not going to pay you. Many employers forget one of those two things, and because of that, if they let you go in the first 3 months, yes, you're going to be owed severance. And remember what I said at the beginning of the show. If you work for a short period of time, your severance can still be substantial. You may have worked for 3 months, and you could be owed 3 months severance. You could be owed 4 months severance, even in the first 3 months. So don't ever assume that just because you've been let go, quote unquote, during the probationary period, that the company doesn't have to pay you anything.
Let me ask you this final question. This is kind of a two-parter. If you've got someone who's maybe not a new employee, a newbie, someone that's a long-serving employee, can the employer, as a form of discipline, or if someone buys the company and say, oh, now you're on probation. You've been here 12 years, but now you're on probation for 3 months.
Doesn't really work, no. I know a lot of employers think that they can do that. They may even try to do that or do it, but it doesn't have any legal effect because you can't eliminate your years of service. If you're a 12-year employee, to use your example, and now you're put on probation, well, guess what? If the company wants to let you go, they're going to have to pay you severance as a 12-year employee. The fact that they called you on probation doesn't eliminate that, not at all. Now, if in fact you've done something really bad, you've committed some sort of a serious act of misconduct, the company can let you go maybe without severance if it's bad enough, but that's not because you're on probation, that's because you did something wrong. So to put an employee on probation as a disciplinary measure is not really effective unless you did something awful, stealing, you hit someone, you committed fraud. You're going to have to get severance if you've already worked beyond your initial probationary period.
If the company's sold and purchased, can the new buyer put you on probation if you're still a long-standing employee?
No, not really. They
Wow.
can't.
No kidding.
Because they inherit your service.
Right.
And because your service has already been more than 3 months, if they put you on probation, it's still meaningless. Meaning, if they let you go even on day 1, as long as you work more than 3 months with the previous company, guess what? They have to account for that service. They have to pay you severance. You don't lose your seniority in that situation.
This is why you watch. You always learn stuff. This is why you watch. 1-855-821-5900, by the way, to reach out, and employmentlawyer.ca. That's where you go to find a radio show that carries our program for the last almost a decade now across the country. We'll get to phone call number 2 from the radio show right now.
And my friend works at the retail store, and recently she had some medical issue, including the minor depression. So she got a note from the family doctor and said that she has to be off work for at least 2 weeks due to the medical issue. But the employer have asked her that the doctor note is not enough, and they want a detailed reason why. I know it's confidential, but she provided a reason to the owner of the store. And the comment from the owner of the store is, I have depression every day, but I come to work anyway, so you have to come to work too. So what's her right over here right now?
It's a big bowl of wrong right there.
I actually remember that call, and I was shaking my head in the studio when that call came. I don't even know where to start, but I'll start by saying that your employer has no say as to your ability to do the job or whether or not your condition is serious or not. The only one that has any say, has all the say, is your doctor. So if you have a doctor's note saying you cannot work, that's the beginning and the end of the story. There's nothing else. You don't need to provide any other information. You don't need to tell your employer what the condition is. They don't have a right to ask you. Doesn't matter if you're suffering from depression or a herniated disc in your back. It does not matter. What matters is whether you can work. And the one that can say if you can work is your doctor. So if your doctor says you can't work, you can be off on a medical leave. Maybe that medical leave lasts a week. Maybe it lasts a month. Maybe it lasts a year. As long as you're under your doctor's care and your doctor says it's legitimate, you can't work, your employer cannot do anything to you. They can't penalize you for taking a medical leave. They can't let you go. They can't question you. They can't find out what medical treatment you're getting, what medication you're taking. None of that is relevant or appropriate. It all starts and it all ends with your doctor.
I know we got a break, but I want to ask you one question before we do that. You mentioned they can't ask what's wrong with you. This is the whole concept of prognosis for diagnosis, right, with your employer?
It's exactly right. So diagnosis means an employer asking questions about what is your condition,
right.
What is your treatment that you're getting, what medication. That is offside. Your employer cannot ask that. You have no obligation or reason to provide information about your diagnosis to your employer. On the other hand, prognosis, all that means is how long are you expected to be out? Is there any accommodation that you need? Those are valid and legitimate questions, and absolutely an employer can and should ask those things. But it cannot cross over to diagnosis. You can absolutely refuse to tell your employer what your diagnosis is.
One more phone call from the radio show is coming up, but first we'll take a short break. 1-855-821-5900 to reach out, and help@employmentlawyer.ca for email anytime as well. We'll continue. More Employment Law Show is coming up. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back. A few minutes to go. Employment Law Show. Thank you for sticking around. It's 30 minutes every week and an hour on the radio is how we do that one. Mentioning the radio, I want to get to our third call from the radio show, Lior, and I know you want to answer it as well. It's coming up right now.
One of my friends was talking about their job recently. They're feeling very unsafe because of a person that works in the building but for a different employer. She has told this to her supervisor numerous times. Nothing's being done about it. So recently she said, I'm prepared to go to the next level, make a complaint. And her supervisor told her that if she did that, she would be fired and a note would go into her work file saying she was a disruptive employee. Is that allowed?
You're a disruptor.
You know, I really hope that there's no one watching this right now that thinks that this is allowed, that thinks that this is appropriate. I mean, you can imagine that it would be no point to even have employment laws if this was allowed. So it's not allowed. You have a right to a free, to work in an environment that's free of harassment, that's a safe environment. Those are such fundamental rights that you all have, meaning if you're being harassed or mistreated or threatened in the workplace, your employer must, not should, but must do something about it. That means investigating it and taking all measures to rectify that situation. And you cannot be punished in any way for bringing up those issues to the attention of your employer. So, of course, she must tell her employer. She must put it in writing. She must file a complaint and put the employer at the task of having to fix that problem. If your employer doesn't, or if her employer does something crazy like punishing her for having the audacity to bring up such a serious issue to the employer's attention, there's going to be some significant legal repercussions and legal consequences. Same with you at home. If you're being bullied, harassed, mistreated, threatened in the workplace, make sure that your employer knows about it. They have to. Put that in writing, by the way. If it's not in writing, it never happened. So send an email, fill out a form, send it by email, do something in writing notifying your employer about what's happening. At that point, they can't ignore it. And if they do, again, there's going to be significant consequences. Always put it in writing. If there's still problems, if you're still not getting the issue resolved, or certainly if you're punished in any way for bringing it up, call me right away.
I want to switch gears for a moment here back to terminationquestions.com. Lior, this one from David writes in, says, my employer implemented a 10% pay cut for all staff, citing lower sales due to the pandemic. When I refused, I was fired for cause. No severance, and I also can't apply for EI. Do I have any options?
So, let's for a second give David's employer the benefit of the doubt, saying that the reason that they wanted to impose the pay cut was because of the fact that there was pandemic issues, that their business was struggling. Despite that, the fact that David said, no, I don't want a pay cut. And by the way, who would say, yes, sure, please give me a pay cut? No one would say that. The fact that he said, I don't want it, and he was let go, does not mean he can be fired for cause. That's a termination without cause, clearly. The employer could have said, we're doing it anyway, and then see what David responds. But they chose to let him go. Because he did nothing wrong, that's a termination without cause, meaning he gets severance. Again, I don't know how long David has been there, but that could be as much as 24 months' pay. Same with you. If you're let go because you didn't want to do something, because your employer imposed a new condition and you said, no, I'm not doing it, and that's why you're let go, that's a without cause termination. These days, John, we're talking about mandatory vaccines. If your employer says, we want you to get a vaccine, and you ultimately refuse, unless there's a government mandate, if you lose your job because of that, that's a without cause termination, despite what your employer says. And you should get severance. You should get EI in that situation. If you find yourself in that scenario, hopefully by now, end of the show, you know what to do. You call me right away.
You know, it's funny, you often mention this in the radio show that employers should put the brakes on because the cost of severance might sink them worse than just having somebody by the sidelines, right?
I don't think employers realize that if they let people go because of the vaccine, they have to pay them severance. And if you're going to lose 10 employees and have to pay each of them $50,000 in severance, that's a lot of money. That's an expense you have to account for because the law says you have to pay it.
1-855-821-5900. That is the way to reach out. Now that we're done, help at employmentlawyer.ca and pocketemploymentlawyer.ca as well. We'll talk to you next time on the Employment Law Show. Thanks for hanging around.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.